I teach at Duke Law School, and I've been working on Second Amendment issues for almost exactly 10 years, the lifespan of Heller, something we'll talk about here in just a minute, and for the next 2 hours. But just to set the stage for our discussion today, and maybe some of the conversation tomorrow, I wanted to just briefly recap some basic aspects of Heller so that we've got some shared vocabulary. So in Heller, the Supreme Court held that the Second Amendment's right to keep and bear arms extends beyond the organized militia, and it encompasses persons and acts and arms that include certain private purposes, like the use of arms for at least self-defense in the home with a handgun, and potentially a great deal more than that. And in the 10 years since Heller, what we've seen are lower courts mostly, with one major intervention from the Supreme Court, trying to determine the contours of that right. And that's not easy, because at the same time the Supreme Court recognized this right, and then 2 years later declared it to be fundamental and enforceable against state and local authorities, the court also recognized that that right, like other constitutional rights, is subject to regulation. So the court at Heller listed various forms of regulation it said were presumptively lawful. Didn't say a whole lot about why, or about what other forms of regulation might be lawful. So in the cases in the last 10 years, courts have really been dealing with what one Fourth Circuit judge called a vast terra incognita, and trying to map and fill that space. We've had more than 1,000 Second Amendment cases in the last 10 years, state and federal, trial and appellate. And the doctrine is sort of starting to take shape. So this is really a wonderful time, I think, to be having this conversation. It's also wonderful that we're having it here because, as the dean said, we've got a fantastic panel with which to have that conversation. I'm going to briefly introduce them and then sit back down while they speak. We're going to start on the end with Professor Glenn Harlan Reynolds, who is the Beauchamp Brogan Distinguished Professor of Law at the University of Tennessee. Professor Reynolds, known to many of you, presumably through his writings online, through Instapundit, and his scholarship. He's addressed issues of constitutional law, the relationship between law and technology, and he's been writing about the Second Amendment for at least 20 years, long before Heller was decided, and among other things, in the mid-90s, used the phrase standard model to describe the view of the Second Amendment which the court would come to endorse, I think 12 or 13 years after Professor Reynolds called that shot. So he can tell us a little bit about the run-up to Heller and sort of the scholarly foundation that he helped lay for the Supreme Court's decision. After that, we have Dennis Hennigan. Denny is currently the Director of Legal and Regulatory Affairs for the Campaign for Tobacco-Free Kids. But before that, for 20 years, he was at the Brady Center to Prevent Gun Violence, where he was, among other things, the Vice President for Legal and Policy Affairs, helped coordinate legal defense for municipalities and states defending their gun laws against constitutional challenges, also helped organize pro bono legal support for people challenging irresponsible gun manufacturers and sellers. And then finally, we have, just to my immediate right, Alan Gura. Alan began his legal career actually here in North Carolina, I think fair to say, with a clerkship for Judge Terrence Boyle on the Eastern District of North Carolina. Then moved to Washington, practiced in private practice and in government, and eventually opened his own private firm, which focuses now mostly on civil and appellate matters. Alan, most notably, argued and prevailed in the Supreme Court's two landmark Second Amendment decisions. One of those, of course, is Heller. The other, practically perhaps even more important, is McDonald versus City of Chicago, which is the case that made the Second Amendment applicable against state and local governments. Alan is regularly listed among top lawyers, appellate and otherwise, in Washington. Although Spencer was kind enough to leave this out of my bio, I was on the litigation team for the district in District of Columbia, writing the briefs, which Alan, we wrote better briefs then, and so it's good to see you again, Alan, almost 10 years to the day when we finished briefing the case in which you prevailed. So the way we're going to do this is I'm going to sit back down, and the panelists, in the order I introduced them, are going to speak for roughly 20 minutes each. Then I'll stand back up. We might have a few questions and some panel discussion, and then we'll open it up for questions from the audience. So please do give some thought to what you might ask these true experts in the field. With that, I'll pass it over to Professor Reynolds.
So let me go back to sort of ancient history. Prior to the 90s, there was some, but not a lot of scholarship about the Second Amendment. A few articles here and there, Hennigan was writing about it in the 80s, and I think even in the 70s. Don Cates had a really kind of a seminal article in the Michigan Law Review called Handgun Prohibition in the Original Meaning of the Second Amendment, which was in, like, I think 1986 or something like that. But there wasn't much. And there wasn't much interest, really, in the subject. Then Sandy Levinson, who's a law professor at Texas, wrote a piece in the Yale Law Journal called The Embarrassing Second Amendment, in which he said, you know, there may be something to this whole idea of an individual right under the Second Amendment, and I think one reason we academics tend to ignore it is we're afraid that if we took it seriously, it might lead to an outcome that we wouldn't politically like. And that was very influential for a couple of reasons. First, it was in the Yale Law Journal. Second, Sandy Levinson is an unreconstructed lefty of the first order, so he couldn't be called a shill for the NRA or the New Right or anything. And second, because he's a super smart guy, and it was a persuasive piece. And after that, there was more interest. So my own introduction came sort of in a different way. The Tennessee Law Review did a symposium on the Tennessee Constitution, and the editor said, you want to write something about the right to bear arms clause of the Tennessee Constitution? And I was like, sure, nobody ever has. The thing I love about writing about a state constitutional provision is it doesn't matter what you write, you automatically get in like the little footnotes and all the annotations and everything, and they kind of have to cite you because, you know, there's nothing else. So I was like, sure, why not? And writing about that got me into a lot of the sort of civic Republican thinking at the time of the framing. I mean, the Tennessee Constitution is just after the framing, it's 1796. So I got kind of into that, and then from that got sort of slid sideways into the Second Amendment scholarship. And then the next year, the Tennessee Law Review said, we want to do a symposium on the Second Amendment. Would you write something for that? And I was like, sure. And so I did, and the piece I wrote, which was called A Critical Guide to the Second Amendment, was basically a synthesis of the individual rights scholarship up to that point. My own original contributions were modest enough. Mostly I just took what a lot of people had written already and tied it together into what was a fairly tidy package, which I gave the catchy name of the Standard Model. Stolen from physics, but you know, we're lawyers, we have to steal from somebody. And it was catchy, which was good, so people started using it, which is always nice as an academic. And basically what I did was looked at the framing era thought about an armed citizenry as a restraint on a tyrannical government, on the militia being made up of, in the famous words of George Mason, the whole body of the people, the idea of armed martial virtue in the citizenry and that sort of thing, and how that translated into the Second Amendment. And as I say, it made a fairly consistent, tidy package, which had a number of conclusions of varying interest. I mean, among other things, I concluded that on that basis, under the Standard Model, it was hard to really make a Second Amendment argument against licensing and registration, since the militia rules required you to actually prove that you owned a gun. So that gave the government some interest in the subject, at least. And it also had the interesting side effect of probably protecting assault rifles, or whatever you want to call them, and other military-style weapons more than handguns and things like that, which was sort of counterintuitive. And it's always fun to be counterintuitive when you're an academic, too. Anyway, we made a pretty nice, tidy package, and people picked up that ball and ran with it, both for and against, for a number of years. And then eventually the Supreme Court decided Heller, and contrary to the kind words spoken, they did not adopt my analysis at all. As a matter of fact, they did something, I wouldn't say it's exactly inconsistent, but it's not at all my analysis. The Heller opinion of the Supreme Court did give some reference to the role of militia as a bulwark against tyranny and the like, but it primarily constitutionalized a right of self-defense. Under Heller, the primary driver for a right for civilians to own weapons was to protect themselves and their household in the event of a confrontation with a wrongdoer, typically a criminal of some sort. And that's a somewhat different take than the Standard Model. Now, to be fair, and this is a point that Don Cates made in a piece in Constitutional Commentary, also I think back in the 80s, the distinction between the two seems bigger to moderns than it did to people in the framing era. In the framing era, a government official who acted outside his legal authority's limits was essentially indistinguishable from an ordinary crook. We tend to defer to authority more, for better or for worse. I personally think it's for worse. If I could just change one thing in the law, it would probably be the abolition of government immunity, absolute or qualified. But that's beyond the scope of this talk. Or maybe it's not. Anyway, so the distinction between protecting against the tyrannical government and protecting against criminals seems more sharply drawn to moderns, I think, than it probably did to the framers, who saw a tyrannical government as just another species of criminal, really. Nonetheless, in the Supreme Court's take in Heller, you wind up basically with somebody like, well, the Heller plaintiffs, who were ordinary citizens living in crime-ridden DC who wanted to own basically handguns for protection and weren't allowed to do so because of the very draconian DC handgun laws, which made it very difficult to own a gun, and if by some miracle you managed to do so, you had to keep it disassembled and separated from its ammunition, which rendered it largely useless in terms of defense against crime. And that, I should note, is a different result than you might get with the standard model. With the standard model, where the purpose of letting people have guns is primarily to defend against a tyrannical government, keeping the guns separate from their ammunition is probably not a big deal. A burglar breaks into your house, you probably have 10 to 30 seconds to do something about it, but usually a revolution takes a little longer than that. You know, enough time to like put bullets in the gun and things like that. So under the standard model, you might actually have gotten a different result there. Probably not, but possibly. Since Heller, of course, we have McDonald, which has made clear that the right to arms also applies to the states. And we've had just a huge amount, I didn't realize it was 1,000 cases, but I'm not really surprised to hear that, of percolation in the lower courts, because the Supreme Court, having sort of ruled on the big picture stuff, you know, that there is an individual right to arms and that it does apply to the states, has basically now kept its hands off and not been very interested in getting further involved in everything else. So we have a lot of questions like, does the Second Amendment right to arms include a right to carry weapons out and about in public? Heller seems to say so. It says there's a right to have and carry weapons in case of confrontation. But it didn't go any farther than that, and that was more or less dictum. It's also the case that Heller included what a lot of us call the Heller safe harbor, which is a paragraph saying that none of this, of course, overrides traditional limits on carrying guns in places like schools or post offices or whatever, which is an exception that some courts have particularly run with. And we've also seen courts working through things like whether the statutory definitions of being adjudicated mentally defective completely cut off Second Amendment rights or cut them off only until you were no longer insane, essentially, and how to figure that out. The extent to which felons can be debarred the use of arms forever, even if the felony was minor and long ago, and a variety of things like that. And of course, a bunch of cases on the right to carry, where you have, well, I don't want to give away tomorrow's panel on the right to carry. I mean, that would be a spoiler, and it would be like telling you that Darth Vader is Luke's father. Oh, I'm sorry. But I will say that the courts have not been overwhelmed with desire to protect the right to carry in public. And that brings me to sort of a couple of interesting things about the Second Amendment to me. My next project will be out in a couple of weeks, actually, from Encounter Books. It's something called The Judiciary's Class War. And I just sort of had this realization a while back that you've got three branches of government. You can elect almost anybody to two of them, but the judiciary is reserved for people who are pretty well off and have postgraduate degrees. And that people who are pretty well off and have postgraduate degrees, and particularly not just any postgraduate degree, but a degree in law, have tendencies to think and act in particular ways, and those ways are surprisingly similar, even across a lot of political divides. The culture there is big. And one example, they tend to really care a lot about protecting words. Judges, they're lawyers, they're members of the chattering class, so the First Amendment gets a lot of protection. Guns, not so much. The Second Amendment is the part of the Bill of Rights that belongs to what Chris Arnade calls the back row kids, the people who don't excel at education and aren't members of the chattering classes. And the courts have been considerably less solicitous there. They have grudgingly gone along eventually, but it is interesting to see the extent to which the court is willing to protect rights that are not explicitly mentioned in the Constitution, but which are highly valued by sort of the educated classes, as opposed to those that are mentioned in the Constitution, but don't enjoy the same degree of upper middle class and above legitimacy. Finally, and sort of as a counteraction to that, what we really have seen, despite Heller and McDonald and all the symposia and law review articles that go with that, which I'm happy to benefit from, is that almost all the real action in protecting rights related to guns is still legislative. We have right to carry in just about every state, depending on how you define it. We have shall issue in the vast majority, and that's purely a legislative, politically driven determination. The judiciary's had very little to do with that. The judiciary has suggested in a few places that an absolute ban on carrying isn't going to fly, but they certainly have not pushed a requirement for shall issue carry. That has bubbled up from below politically. Many of the other protections, the end of the assault weapons ban and such, have happened for political reasons. So really most of the protection of what we call Second Amendment rights has been driven by the two branches of the government that are not reserved for wealthy people with postgraduate degrees. There may be a lesson in that with regard to other constitutional rights and other aspects of our society as well. That's sort of beyond the scope of this talk, but as the old mathematics textbooks say, I'll leave that one as an exercise for the reader, in this case, the listener. There we are. I'll turn it over to Dennis.
Thank you, Glenn. I guess I got to get this thing geared up. Okay, is that working okay? Yeah. Well, first of all, I want to thank the Campbell Law Review for including me in this symposium, and have to confess that I was somewhat surprised to have been invited to join you, because I think I can fairly be regarded as a historical relic of a bygone era. I have not been active on the Second Amendment front for about 5 years. I think more about e-cigarettes than about AR-15 at the present time. That bygone era, of course, is the pre-Heller-McDonald era, when the debate was about what is the Second Amendment about? What is the subject matter of the Second Amendment? Is it about an individual right to have a gun for personal reasons, or is it an entirely militia-centric right? I confess, on the losing side of that debate, and I expect to be reminded of that several times during this symposium, probably by Alan, if no one else. Even though I'm not an active participant in this debate, I'm very much an interested observer. So I'll try to bring somewhat of a unique perspective to this symposium, that of someone who remains a strong believer in gun control, but is somewhat on the outside looking in to the current Second Amendment debate. So as we contemplate the 10th anniversary of the Heller decision, I want to address three questions which gun control advocates and others were asking at the time the decision came down, and address whether the last 10 years might have helped us begin to answer some of those questions. The first question is, will Heller itself survive the test of time? The second question is, will gun control laws survive Heller? And the third question is, what impact will Heller have on the continuing national debate about the role of guns in our society? So let's turn to the first question. Will Heller itself survive? I think this is a legitimate question. The Supreme Court sometimes overrules its own decisions. Sometimes it takes decades, as it did when Brown v. Board of Education overruled Plessy v. Ferguson, but it has happened in other instances in less than a decade. I think it's a legitimate question to ask about the Heller decision. It was, after all, a 5-4 decision That itself was a sharp departure from Supreme Court precedent in U.S. versus Miller. And in my view, Heller was a potentially fragile ruling. And I say that because it was an originalist analysis built on a historical house of cards. The majority in Heller got the history wrong. How do we know this? Well, ask the historians. Professor Paul Finkelman is part of this symposium I'm so pleased to see. He wrote this about the Heller decision. While the justices in the majority professed to believe in a jurisprudence of original intent, the court's historical analysis could not get a passing grade in any serious college history course. Of the 16 historians who joined amicus briefs in Heller, only one supported the analysis adopted by the majority. And I believe that historian, Joyce Lee Malcolm, is also part of the symposium, which I'm pleased to see. In McDonald, 24 historians joined an amicus brief, arguing that the Heller majority got the history wrong. And in fact, Justice Breyer's opinion in the McDonald case suggested the potential vulnerability of an originalist decision that is based on faulty history. Justice Breyer wrote, "If history and history alone is what matters, why would the court not now reconsider Heller in light of these more recently published historical views?" But of course, he knew that wasn't going to happen. But Heller's vulnerability, of course, depends entirely on changes in the membership of the Supreme Court. If Merrick Garland had been confirmed as a Supreme Court justice, there's a distinct possibility, in my view, that Heller would have been overruled. As a judge on the D.C. Circuit, he voted for an en banc rehearing of the panel ruling in the Parker case, which of course led to Heller. If Hillary Clinton had been elected president, it is quite possible that she would have changed the court's membership in a way that constituted a real threat to Heller. But as we all know, elections matter. With the election of Donald Trump, Heller is here to stay at least for a while. But it won't be because of the decision's jurisprudential strength. It is, in fact, an originalist decision that defies history. Well, let's turn to the second question. Will gun control laws survive Heller? The stakes for our society here are very high. I know this symposium topic is not gun violence or gun policy, but it would be a mistake to assess the first 10 years of Heller without considering it in the context of the continuing tragedy of American gun violence and the continuing debate over how to respond to that tragedy. The trauma of American gun violence likely is having a profound impact on judicial decision-making on the constitutional validity of gun laws. It is impossible for judges to assess the meaning of Heller for gun laws under challenge without some consciousness of the dimensions of gun violence and its impact on American society. And from any perspective you want to look at it, our country has a gun problem. Americans make up about 4.5% of the world's population. We have 42% of the world's guns. And we have rates of gun violence unheard of in the rest of the industrialized world. The U.S. homicide rate is 7 times that of other high-income countries, and it's driven by a gun homicide rate 25 times higher. American children ages 5 to 14 are 18 times more likely to die of a gun homicide and 11 times more likely to die in a gun suicide than children in other high-income nations. In those high-income nations, the U.S. accounts for 90% of gun deaths of children under the age of 14. And though public mass shootings represent a tiny percentage of American gun deaths, the profound trauma of these events affects every American. There are places across this country that are now recognizable by millions as sites of unspeakable bloodshed. Columbine, Virginia Tech, Tucson, Newtown, Charleston, Orlando, Las Vegas, Sutherland Springs. And Americans wonder, and I hear them ask this all the time, is there any end to this? Are these mass shootings a permanent, horrifying feature of the American landscape? And I'm quite sure that judges are asking the same question. So what has been the impact of Heller on laws enacted in response to the tragedy of American gun violence? Well, at the time the decision came down, many feared that Heller would be the beginning of the end of gun control. Jeffrey Toobin has written that after the Heller decision, quote, it appeared that all attempts at gun control might be doomed as a matter of constitutional law. And I'm sure there are some, maybe many in this room, who hoped Heller would have precisely that impact. It's certainly fair to say that for the gun rights movement, the point of the Heller lawsuit was not simply to strike down local handgun bans, of which there were only 2 in major American cities, but to establish a precedent that could be used to unravel the fabric of American gun laws. And that clearly hasn't happened. As a threat to current gun laws, Heller has largely been a paper tiger. One analysis, which said there are over 1,200 cases in which gun laws have been challenged since Heller, found that courts have rejected those challenges 93% of the time. And it's worth reciting some of the significant categories of gun laws that have been repeatedly upheld. Bans on gun possession by felons, even nonviolent felons, and other categories of high-risk individuals, including domestic violence misdemeanors, waiting periods and background checks, gun registration, including fingerprinting and photographing of registrants, safety training requirements, bans of machine guns, assault weapons, and high-capacity magazines, safe storage requirements, bans on carrying concealed weapons, and other restrictions on the public carrying of guns. And the Supreme Court has showed little interest in reviewing these decisions. It has declined to review at least 82 Second Amendment cases since Heller. Now, the reluctance of lower courts to overturn gun laws and the reluctance of the Supreme Court to review those decisions has produced some sharp reactions from some of the Supreme Court justices. Dissenting from the court's denial of certiorari in the Seventh Circuit decision upholding the Illinois ban on semi-automatic assault weapons and high-capacity magazines, Justice Thomas, joined by Justice Scalia 2 months before his death, complained that the Seventh Circuit had relegated the Second Amendment to a second-class right. And last year, Justice Thomas wrote a dissent, joined by newly minted Justice Gorsuch, from the denial of cert to review the Ninth Circuit en banc decision upholding California's restrictive concealed carry law. Justice Thomas noted a distressing trend, the treatment of the Second Amendment as a disfavored right. Justice Thomas noted the Supreme Court has not heard oral argument in a Second Amendment case since the McDonald argument in 2010. So with certain exceptions, and I would say most notably the D.C. Circuit ruling in Wren versus District of Columbia last year, striking down D.C.'s restrictive concealed weapons law, Heller generally, I believe, has been a sharp disappointment for gun control opponents who thought it would turn out to be a lethal weapon to be used against gun laws at every level. And it's interesting that no major gun control organization that I know of has attached any priority at all to overruling Heller. Contrast that with the decades-long campaign to overturn Roe v. Wade. Why? Likely it's because Heller has not yet had a significantly adverse effect on the nation's gun laws. Well, let's turn to the third question. What has Heller's impact been on the gun control debate? Well, I described Heller as a fragile decision, at one time at least, quite vulnerable to being overruled. But it may be that the demise of Heller would be the worst possible result for the gun control movement. And I've called this the Heller paradox. The overruling of Heller today would unleash an explosion of pro-gun activism that would be a far greater threat to American gun laws than Heller itself. Professor Adam Winkler of UCLA Law School has put it this way: overturning Heller, he wrote, would spark a backlash that would make the political movement to reverse Roe v. Wade seem like a schoolyard kerfluffle. In his Heller opinion, Justice Scalia declared that the majority ruling had taken certain policy options, namely handgun bans, off the table. Well, Heller took broad gun bans off the table not just as a constitutional matter, but also as a feature of the gun control debate. Whether private possession of handguns should be prohibited is simply no longer a live issue. And in my view, that is a positive development for gun control forces in this country. Because the NRA has always wanted the debate to be about banning guns. It makes it easier for the gun lobby to convince gun owners that far more is at stake in the debate than whether background checks should be applied to all gun sales, the kind of policy recommendation that has the support of even a majority of gun owners. The NRA, and I know this from experience because I've been involved in many of these debates, the NRA strives to cast gun control as an attack on a valued personal possession that is itself a powerful symbol of individual freedom and indeed a symbol of a way of life. And that's why slippery slope argumentation is so important to the pro-gun forces. Every gun control proposal, no matter how modest that is proposed, is framed as one more step down the slippery slope to a gun ban or gun confiscation. That's the argument that the gun lobby uses to try to turn this issue into a cultural issue. Heller may, over time, and it may take some time, may function to actually flatten the slippery slope and allow the debate to focus much more on specific policies that are simply sensible responses to gun violence and that have the support of even a majority of gun owners. And I can tell you, the NRA does not want to fight on that terrain. So yes, it looks like Heller is here to stay. But if Heller continues to be a paper tiger in the legal attack on gun laws, and actually functions to recast the gun debate in this way, the gun control movement may be able to live comfortably with Heller for some time to come. Thank you.
Well, thank you so much, everybody. Can you hear me? Okay, now the microphone's working. Well, thank you so much. I'm always happy to be back here in Raleigh, where I clerked for a little bit to start my legal career, as the dean noted, and also I've spoken before at this wonderful school. I'm so glad to have such an opportunity to share the stage once again with Dennis and with Professor Reynolds as well. I'd like to address some of the commentary that's been made here by Dennis, and I think he may be surprised that I actually agree with him a fair amount, more than he might suspect, at least about some of what we've seen and what we might expect to see as a political matter arising to and related to the Heller decision. I do agree with Dennis. I think it's fairly obvious that many judges have simply not accommodated themselves to the decision in Heller. They don't think it's legitimate. They don't believe that it's real. And absent actually being compelled by the Supreme Court to do so, they will not enforce it. It is quite obviously a dead letter in much of the United States. I don't think there's any serious question of that for anybody who reads the opinions. And it's not just the 1,100 or 1,200 or 1,000 opinions that we can cite about. It's actually just a select few that we can look at, and I'll discuss them in a short while. I think it's misleading to look at the raw number of total opinions that reject Second Amendment arguments because, quite frankly, every day in America you have thousands of judges across the land hearing and rejecting arguments by people raised under the Fourth Amendment. People want to suppress evidence that's been seized from them to be used against them in trial. Most suppression motions are not successful. There are First Amendment arguments that are raised quite a lot, and it's not surprising that someone facing a very lengthy jail sentence for being a felon in possession of a firearm might throw in one of these kitchen sink arguments about how Heller abolished the felon in possession ban as a facial matter. Those types of arguments don't get anywhere, but they do ring up the tally back in the Brady Center's office. But ding, ding, another Second Amendment case got rejected. So the raw numbers are not really what I would look at. I would look at a select few, but quite telling landmarks, I would say, that really show you how much the decision is eroding. And like I say, I'll get to that in a minute. So is Heller something that's going to survive? Given the intensity of the resistance to it, I am not so sure that it will. It's interesting that a couple summers ago in 2016, I was invited to be sort of the symbolic pro-gun rights speaker at a panel at the American Constitution Society's National Conference. And the debate that we had there, remember, this is the summer of 2016. Everyone's sure that Hillary Clinton is about to be inaugurated. And Merrick Garland is going to be confirmed, or maybe even somebody better from the left's perspective. The question was not whether Heller would survive, but how would it die? And I was the one voice on the panel who said, well, as soon as they get to 5, they'll overrule it because they just can't stand it. And most of my friends on the other side said, no, you don't have to worry about that. They'll keep it around because it's too politically devastating to overturn for all the reasons that Dennis regaled you with. It just won't mean a whole lot. It'll just be narrowed, into nothingness. And that, didn't seem right to me. I too saw the votes come in, including Judge Garland's vote in Parker, and I didn't think that the left would accommodate Heller for 5 seconds. Nonetheless, whether it's overruled as a formal matter or overruled by neglect or by willful disobedience, the end result is the same. This is a decision that, I suppose like any other decision that's published in U.S. reports, only means something if judges are there to enforce it. In that way, Heller is no different than any part of the Constitution itself. We have this parchment, and it says all kinds of interesting things about the limits we place on government and the power that we grant the government. But when push comes to shove, if the judges sneer at it and they simply are unwilling to give it any effect, then our Constitution is no more effective than the glorious freedom-granting, securing constitutions that were enacted by Joseph Stalin in 1938, and we could probably find other examples, right? It's not hard to draft a constitution which generously secures rights. Sometimes it's a little bit harder to find judges who are willing to enforce it, and we've had some meaningful judicial resistance to Heller. If the judges or justices continue to resist or overrule Heller formally or informally one way or another, I do suspect it will be for the class-based reasons that Professor Reynolds noted, and not so much because the history of Heller is all wrong. I commend the opinions, both historical opinions in Heller, Justice Scalia's opinion from the majority, as well as Justice Stevens' more erroneous opinion, to anyone who can read them and compare them side by side. There's no shortage of literature out there about the history of the Second Amendment, and I think it speaks largely for itself, and it's beyond the scope of this discussion tonight for me to sit here and re-argue the history of Heller for you. But the idea, the notion that only capital H official certified historians are allowed to participate in this debate is something that's always bothered me. Earlier on in the debate, the pre-Heller debate about the Second Amendment, we would see this line from the other side come in once in a while that would say, well, this is law office history. That's sort of a way to deride it. That we are real historians who, of course, are totally neutral, have no political values whatsoever. You grab 100 historians from any campus in America, you have no idea how they voted in the last election, right? Or how they might feel about the general social issues of the day. They're all neutral arbiters. They're cold scientists looking at history, and of course, who can argue with them? And there have been some very official capital H card-carrying historian members out there writing about the Second Amendment, like Michael Beliles, right? We all remember the scandal when a former professor, he's a former professor now, right?
I'm not sure everybody here does remember it.
Yes.
You might just sketch it out briefly.
So this book came out a number of years ago, which purported to show through historical records that Americans didn't really have many guns, didn't much care about guns, that this is essentially an issue manufactured by latter-day lobbyists of the NRA and other nefarious organizations. And this book was lauded, everybody blurbed it, it was a fantastic book, it was awarded, I believe, the Bancroft Prize,
Yeah, the
right?
Bancroft Prize.
Bancroft Prize, very nice, except that the records that were cited to support some of the assertions in the book would have been destroyed in the earthquake in San Francisco in 1906. And as people started to do more and more digging in the footnotes, they found that this was essentially fabulism. I mean, this was not a true account. The history didn't hold up. The Bancroft Prize, I believe, was withdrawn. Professor Belaya, I believe, is no longer teaching history at Emory. I think they pulped the book, right? Official historian. You know, use your judgment when you read things. Check the footnotes and see if the things are there. By the same token, I, myself, when I have these debates, do not demand that people certify themselves or qualify themselves anyway to speak about history. For example, one of the most prolific historians on the other side of this debate is a gentleman named Patrick Charles. I met him once. He's a nice guy. You know, I don't agree with him. I disagree with his views that he writes, and I would always meet him on those views. If I were to debate him, if I were to disagree with something he's written, I would address his arguments. I would not address him. Interestingly enough, he wound up as one of the historians on this historian's brief, I think, at McDonald, and he is an historian. I mean, it's how he holds himself out. It's what he studies. He studies history. He has a BA in history, I think. Okay, that's fine. You know, I'm not going to say that he's not a real historian. Ultimately, I side with what Judge McConnell told Judge Posner at a debate that I was privileged to see a number of years ago at the Federal Society's annual convention. Judge Posner, a critic of Heller, went on and on and on about how the Supreme Court are not historians, their clerks aren't historians, what do we know? Let the historians figure out the history. And after he got himself going on this tangent for a while, the response from Judge McConnell was perfect. He said, we're not economists either. And for those of you who are familiar with Judge Posner's groundbreaking work on law economics, you see the problem. In fact, anyone here in Raleigh should understand the problem of trying to prevent lawyers from arguing about matters that are allegedly outside their expertise, because law is a profession that translates other people's expertise into practical reality. Here in Raleigh, when I clerked here on the local federal court, the district encompassed Research Triangle Park, and so yes, there were pharmaceutical patent cases that were heard here. And we had a big one when I was clerking, Glaxo versus Nova Farm, and I don't have any expertise in synthetic organic chemistry, and neither did my boss. But we had a trial, and the Federal Circuit affirmed. So, you know, I guess we got it right. That's the wonderful thing about law is that you can learn about other disciplines, you can engage yourself in other areas, and you can present it, translate it into practical reality. History is most suitable for lawyers because, after all, you're dealing with the written word. And anybody can read original documents if you understand the language and understand the language of the day and come to your own conclusions. Obviously, historians are people who do this more so than other people, and they specialize to some degree. Perhaps if they study a particular period in time or an area, they know more about that readily off the top of their head. But this is not something that's outside the province or ability of lawyers to understand and judges to rule upon. And so it's quite appropriate for the Supreme Court when it is called upon to interpret the Constitution, to apply the Constitution to present-day reality, to ask themselves, what did the framers of this text understand this text to mean? How was this language used during the day? And those concepts that were then enshrined are the concepts that we are to apply today. If the Constitution does not mean what the framers thought it meant, then it doesn't really mean anything, right? They're just words in a paper, and you can fill in the blanks or empty vessel, and you can pour whatever content you want into those provisions. So I don't think Heller is vulnerable on the history. I think it makes quite a bit of sense on the matter of history, but the problem is that we entrust this process, as we have to. Somebody has to make these decisions. We entrust it to a class of people who, by and large, are unwilling to accommodate themselves to this and don't believe it and don't care and aren't going to enforce the decision. It might as well not have been issued in some courts. I proceed here with caution because there's an old aphorism that provides that you should never tell people your problems because 90% of them don't care and the other 10% are happy. So I don't like to go around, sounding like sour grapes. Oh, I litigate the Second Amendment. Let me tell you how terrible it's been. I have not filed all 82 cert petitions that Dennis talked about that were denied, but I filed enough of them to get a flavor of where this is going. And the reality is that I and other lawyers have clients who come to us. They have real serious questions that arise under the Second Amendment, questions that, regardless of how you think they should turn out, any fair-minded attorney or judge could say, well, that's an interesting Second Amendment question. A court should decide this. And I ask the potential client, where are you? And if they are within certain circuits, I say, forget it. It doesn't really matter. Because you can't get a panel that's going to buy it. And it doesn't matter what the facts are. It doesn't matter what the law is. You see the type of decision-making which can only be called results-oriented. And before you think this is just me saying it, that this is just some right-wing gun advocate who's unhappy that he can't get all the victories he wants, let me cite to you two folks who are not usually thought of as the militia leaders. I start with a former colleague of Dennis Hennigan's, I think, Alan Rostrom, right? I don't know, he was a sitting right there. Fantastic. That's right. Duh. I love your article. I cite it all the time. If there's some place that counts all the citations to an article in briefs and petitions, I am really running up your score because Dean Rostrom wrote a really, I think, good article, which I agree with in many ways, entitled "Justice Breyer's Triumph in the Third Battle Over the Second Amendment." For those of you here at home, that's the 80 George Washington Law Review, 703, right? Yes. Okay. And just the title of the article, which came out, 6 years ago, tells you the story. Courts are treating Justice Breyer's dissent essentially as the controlling opinion in Heller. Justice Stevens, you'll recall, wrote the historical bit. Justice Breyer said, well, even if it's a right, let me explain to you why. It doesn't mean a whole lot. And he applied a very deferential interest-balancing approach to suggest that even DC's very extreme law would be upheld. Even back then, people could see that this is really what the courts are following. By any other, you can call it what you want, but Justice Breyer's interest-balancing approach is what is carrying the day in so many federal courts. More recently, joining the party, we've had Richard Ray from UCLA Law, also publishing an article in the Georgetown Law Journal where he talks about the concept of narrowing Supreme Court precedent from below. This is the title of the article. And the idea is that there are some decisions of the Supreme Court that are either so wrong or so practicable or so offensive, for whatever reason, they are narrowed from below by the lower courts that don't give them the most reasonable construction, but give them the most palatable one, or at least palatable to the judicial class. Now, as far as I can tell from reading the article, which I think is very persuasive, and he cites different areas of law where he thinks this is happening, and of course Heller is one of these areas, and Ray writes that the passage of time has seen Heller's legacy shrink to the point that it may soon be regarded as mostly symbolic. I can't argue with that. I think that's true. He thinks this is a good thing. What I suggest to you is put aside whether you think this is good or bad from a normative standpoint about gun laws, how you feel about firearms and gun rights, whether this is good or bad for America. Ask yourselves what this does to us as a nation that's supposed to be a nation of laws and not men or women. We have female judges too. I mean, is it really the fact that we are the kind of country, the president has used words recently to describe certain places where the rule of law does not usually carry the day, where you go to the lawyer's office and the lawyer says, well, you're going to win or lose based on who the judge is sitting today. is that really what we want for anything, but most especially for the Constitution? We have an understanding that we teach at this law school and others, that we have a system of vertical precedent. The Supreme Court is up here, then you have the intermediate courts of appeal, then you have the trial courts. Every state has its own hierarchy. And when one court says something, the lower courts are supposed to follow it. And that gives the law its essential value, predictability, right? One of the values that law does is it informs us what our rights and duties are. How are we to behave? How will the next case turn out based upon the reasoning of the previous case? And that requires judges to make decisions that they don't personally like. So even if you think Heller is wrong and horrible and terrible, the history was bad, the consequences for America are terrible, it caused all these problems, that's all well and good, but this is the Supreme Court's doctrine, and now we have very intelligent scholars who are not, gun rights advocates by any measure, who can come in and tell you, as an objective matter, this is a symbolic opinion. This is not given its best construction. People are following the dissent. I would make a prediction that if this phenomenon were to continue, that a lot of the people who are okay with the practice might someday have some very long faces when the tables are turned and something that they care about as a matter of precedent is limited into oblivion. But what I'm mostly concerned about is not the feelings of people on the other side, and we can laugh about turnabout and fair play. I'm mostly concerned about what this is doing to Americans, to my clients, and to people in the public who are becoming cynical about the mission of the federal courts in particular. And it's hard to look at some of these decisions and not say, come on, this is just a disagreement with Heller. I could bore you all night with examples of this. I feel obligated to give you maybe one or two, okay? Writings from judges that I'm not sure reflect the most allegiance to Heller. Let's start with a case that I litigated in Illinois, a case called Moore versus Madigan. This is the case that struck down Illinois' total ban on the carrying of guns for self-defense outside the home. And there was a petition to have it reheard en banc, which was denied, and we won. That was great. The dissenters from the refusal to rehear the case en banc, not unreasonably and not wrongly noted that Illinois could still regulate the carrying of handguns outside the home. This is not the end of all gun control. Yes, people have to be able to carry a gun somehow, but there's going to be some room for regulation. But in their predictions of what regulations would be acceptable, one piece of advice really has stuck with me ever since, and I'll read it to you. The court seized upon the concept that even if you can carry a gun for self-defense, there are going to be some so-called sensitive areas where you can be excluded from having a gun, and that makes perfect sense. I mean, I flew here tonight from Washington. I cannot take this water bottle through TSA, right? For sure, I can't bring a gun if I wanted to. So there are some places where, and we can dispute about how we identify these sensitive places or what they might be, what are the standards the court should apply. But here's a list of sensitive places that the dissenters came up with. It should not be difficult to make reasonable arguments to support extending that reasoning, the sensitive place prohibition, to areas around, okay? Areas around, what's an area around? 50 feet, 100 feet, 1,000 feet? Areas around, here it comes. Schools, courthouses, other government buildings, public universities, public libraries, hospitals, medical offices, public parks, forests, churches, and other places of worship, banks, shopping centers, public transportation facilities and vehicles, and venues for sporting events, concerts, and other entertainment, among many possible examples. What's left? You have the right to carry a gun, not around a forest, or a building, or a person, or a molecule. I mean, this is not a reasoned attempt to find the limits of a constitutional right. This is an exception that would swallow the rule, and I don't think it would fly, at least not by a majority of judges who are willing to apply the Second Amendment. But here you have, obviously, you could form a majority of of 2 out of 3 judges out of these dissenters who would say, oh, banning guns from all these places and areas around them, that's just fine. The other case that I always think is a wonderful example of refusal to abide by Heller is Kwong v. Bloomberg. This is the case of New York that upheld. New York City requires you as a condition of having a gun to register it, fine, and it's $340, I believe, every 3 years. So it's over $100 a year just to possess a handgun in your home. That's not including all the fingerprinting and license and other fees. And New York's position in the case was, hey, we're doing you a favor because the real cost of administering our gun control regime is closer to $1,000 a year. So it's a bargain. And the court held that charging people $340 to exercise the right to have a handgun in their home for 3 years is not even an appreciable restraint on the right. And they didn't even apply heightened scrutiny to it. They decided under essentially rational basis, but they said, oh, but we would uphold it under intermediate scrutiny, would get more than that, because the money goes to a good cause, namely the city of New York. How would that panel have addressed a case brought by people who said, I need to show an ID to vote, and it costs like $10 to get a state-issued ID for 10 years or whatever? I actually looked it up in New York. It's something symbolic around that level. Oh, this is terrible. This is, you couldn't charge them a nickel. You couldn't even make them get a free ID in many courthouses. But hundreds of dollars, it won't bankrupt you. You didn't say it would bankrupt you, so we're going to approve it as a matter of rational basis. I could go on, there are other examples, but we do have a problem, I think, with essentially judicial lawlessness. One more example, the case that was mentioned here about the assault weapons ban in Highland Park, Illinois. The reasoning of that case was a little bit different than we see in other types of assault weapons ban cases. I suppose that there will be a panel tomorrow discussing this. The reasoning that the Seventh Circuit used to uphold the ban was that regardless of whether these weapons are harmful to society, incidents where the weapons are used have high salience in the public consciousness. And so this law makes people feel better, and that's a sufficient value that allows prohibiting the possession of something that would otherwise attain protection under an enumerated constitutional right. It makes people feel good. That's the new standard for infringing upon an enumerated right. That's hard to accept, and yes, people don't like guns, and I get that. But see if you would like that reasoning applied to your favorite right, whatever it might be. Where are we going? We're not going anywhere unless we have different judges making these decisions. And, that's essentially, at the end of the day, a function of politics and democracy. And it's sad to say that. I mean, on the one hand, I'm happy with many, if not all, of the recent nominees that have been made throughout the country. I think these are, by and large, except for 1 or 2 people that didn't get confirmed, these are, certainly at the appellate level, all highly qualified folks. I'm not going to agree with all of them in every case, but I think that these will be men and women who generally respect and understand and will seek to apply the Second Amendment whether they have lots and lots of guns or not. It's sad that it requires political controversy to be able to hope that you get enough people who would do that.